Criminal fraud charges in Cherokee County can be misdemeanors or felonies depending on the type of fraud alleged, the amount of money or property involved, the defendant's criminal history, the number of transactions, and the exact statute charge. Fraud is not one single crime in Oklahoma. It is a broad category of offenses that may include false pretenses, bogus checks, embezzlement, forgery, identity theft, credit card fraud, insurance fraud, computer fraud, and financial exploitation. The misdemeanor or felony question usually depends on the facts. A lower dollar allegation may be filed as a misdemeanor. A higher dollar allegation, repeated conduct, a forged document, an identity theft claim, an employee theft allegation, or an organized scheme may be filed as a felony. Fraud is a broad term. People often use the word fraud to describe any dishonest financial conduct. In criminal court, however, the state must charge a specific crime. The exact charge matters because each fraud-related offense has its own legal elements and punishment range. For example, a bogus check case is different from an embezzlement case. A forgery case is different from an identity theft case. A contractor dispute is different from a credit card fraud case. The defense must begin by identifying the precise statute charged and what the prosecutor must prove. Misdemeanor fraud charges. Some fraud allegations may be misdemeanors when the amount is relatively low or when the statute classifies the offense as a misdemeanor. Under Oklahoma law, obtaining or attempting to obtain money, property, or something valuable by trick, deception, false representation, false pretense, confidence game, or similar means is generally a misdemeanor when the value is less than $1,000. A misdemeanor fraud conviction can still carry serious consequences. It may result in jail time, fines, restitution, probation, court costs, and a criminal record involving dishonesty. Even a misdemeanor fraud conviction can create problems with employment, licensing, housing, banking, and reputation. Felony fraud charges. Fraud may become a felony when the value involved reaches the felony threshold, when multiple transactions are part of a common scheme, or when the specific fraud statute treats the conduct as a felony. Many fraud-related offenses are commonly charged as felonies, including certain forms of embezzlement, forgery, identity theft, financial exploitation, and larger false pretense cases. Felony fraud charges are much more serious. A felony conviction may result in prison exposure, probation restrictions, restitution, fines, a permanent felony record, and long-term consequences for employment, professional licensing, business ownership, firearm rights, and public reputation. The amount of money matters. The amount of money or property involved often affects whether a fraud case is treated as a misdemeanor or felony. However, the amount is not always as simple as the complaining witness claims. The defense should carefully review whether the alleged loss amount is accurate. In many fraud cases, the amount claimed may include civil damages, interest, attorney fees, or amounts that were already repaid. The defense may be able to challenge the alleged value and argue that the case has been overcharged. Multiple transactions can change the charge. A fraud allegation involving several smaller transactions may be treated more seriously if the state claims the transactions were part of a common plan or scheme. For example, several bogus checks or repeated false transactions may be combined for charging or punishment purposes under certain statutes. This makes the timeline important. The defense should review the dates, amounts, people involved, documents, payments, communications, and whether the state can actually connect the transactions as part of one plan. Fraud requires intent. Fraud usually requires proof of fraudulent intent. A person should not be convicted simply because a business deal failed, a debt was not paid, a project was not completed, or a promise was broken. The state generally must prove that the accused acted with intent to cheat, deceive, or defraud. This is often the most important issue in a Cherokee County fraud case. The defense may argue that the situation was a civil dispute, contract disagreement, accounting mistake, poor business decision, misunderstanding, or inability to pay rather than a crime. Civil dispute versus criminal fraud. Many fraud cases begin as civil disputes. A customer may claim a contractor failed to finish work. A business partner may claim money was misused. A lender may claim financial information was inaccurate. A family member may claim funds were mishandled. A client may claim services were not performed as expected. Not every civil disagreement should become a criminal fraud case. Evidence showing partial performance, attempts to repay, ongoing negotiations, disputed contract terms, permission to use funds, or a good faith belief in the transaction may support the defense. Common defenses to fraud charges. Possible defenses to fraud charges may include lack of intent, good faith belief, mistake, lack of knowledge, consent, authority to act, insufficient evidence, mistaken identity, false accusation, inflated loss amount, civil dispute, unreliable records, or constitutional violations. The best defense depends on the charge. In an embezzlement case, the issue may be whether the accused had lawful authority to use the money. In a forgery case, the issue may be whether the signature was authorized. For a bogus check case, the issue may involve knowledge, timing, notice, payment, or whether the state can prove intent to defraud. Restitution does not automatically mean guilt. Fraud cases often involve restitution claims. Restitution is money the state or complaining witness claims should be repaid. However, the fact that money is allegedly owed does not automatically prove criminal fraud. A person can owe money without committing a crime. The defense should carefully examine whether restitution is supported by reliable evidence, whether the loss amount is connected to the charged conduct, and whether the amount includes improper civil damages. Speaking with a criminal defense lawyer as early as possible can make a difference in the outcome of your case.